Okay, well, today we're talking about virtual programming. And those of you who are Library Law Spotlight fans who come a lot to these, groupies, may I say? No, I'm just kidding. We actually did this. I actually did this in February of 2020. So I did this almost a year ago when we were midst pandemic. We were kind of at the beginning of the pandemic. Or I guess it would almost be almost 2 years ago now. Geez. So I thought maybe it would be good to refresh it since libraries are continuing to do things virtually, and there's a lot of innovative things going on with regards to programming digitally and virtually. So I thought it would be good to kind of update this and maybe kind of just do a little refresher. So this is my disclaimer, which as most of you probably know, my job here as the library law consultant is to provide information. So it's to provide information to help you understand legal issues, to help you understand what your options could be with legal issues, but I cannot advise you or give you legal advice. Here's my contact info if I can assist you or if you need some information. Sometimes it takes me a little while to get back because I have a lot of requests in addition to other things, work things that come my way. But if you send me a request, I will get to you, and don't hesitate to nudge me if you have an emergency or you have a deadline. Okay, so what we're going to talk about today in context of virtual programming is we're going to talk about your overall data security, which is becoming a really big issue right now. It's kind of been growing over the past couple years, maybe even longer than that. It's kind of been slowly kind of climbing this hill, and it's getting to the peak of that hill. This is a lot of the law things that I review are starting to become all about this data security issue. We're going to talk about some privacy issues which are related to the data security, but also there are some related to other laws. Age issues that can pop up with regards to virtual programming. We're going to talk about gaming, depending on the kind of program that you want to have. The ever-present copyright issue. We might throw a few cyberbullying things in there. And I'm going to add a thing or two about social media. We're going to do a separate social media presentation because that's a whole other area for libraries that's a legal area that we're going to talk about. But there is one particular part of this, of the social media legal issues that kind of dovetails with the virtual programming. So we're going to bring that up as well. So let's start with talking about, before, when you're thinking of creating a program virtually, what are some of the legal things that you should consider? And so we're going to open up with data security. So when I talk about data security, what I'm specifically referring to is the possibility or the safeguards in place to prevent a data breach. Right? So it's about securely holding information, personal information that you use all the time. So things like patron records, as well as information that you maybe no longer need, including information that you may print out from those patron databases. Okay, so all of this is kind of part of data security. Right now, there are multiple laws in place that can make libraries liable for breaches of information. And a breach of information can be anything from what you think of when you hear the word data breach, which is, ransomware or a virus or something where, hackers get into your information and steal it or copy it. But data breaches are also if you have, staff in the course of doing their work, print out a list of patron records and then, throw them in the garbage without shredding them, or leave them on their desk, or leave them somewhere in plain view of the public. That could also be a data breach. So a data breach isn't necessarily that someone has taken the information and used it inappropriately. A data breach, depending on the law, could just be that the information was left out in plain view of the public for anyone to see. So someone doesn't have to use the information in order it to be a problem. So the first law about this, there's federal laws and there's state laws on this. The first law is the Library Privacy Act. Now we're going to talk a little bit more about this later, but under the Library Privacy Act, and this was something that was not true when I first did this presentation in February of 2020, because of amendments that were made to the Library Privacy Act since. Before, well, it was kind of true, but it wasn't clear. So right now, as of the amendments to the Library Privacy Act, a public library, as well as the library board, the library staff, volunteers, could be liable for a breach of data if that breach was done knowingly. So if a library staff member printed out a list of patron records or personal information of patrons, but in the Library Privacy Act, it's actually broader. It's just a record, anything that's a library record. So let's say you print out a list of overdue books with names and everything like that. If that document is not treated appropriately, if it's just kind of carelessly left on a maybe on the circ desk and the person goes off duty and forgets it and just leaves it there in plain view, that could be a problem. If your ILS product does not have adequate security protocols, or your network doesn't have adequate security protocols, and something happens and your network provider has a breach, and that breach made it possible that your patron records were laid bare or made accessible, then that could be a problem. If you have a vendor that you work with for anything from getting your library cards remotely, how now libraries have, people can register for cards remotely through the computer, or registering for programs, or anything like that, and that particular product is not secure, so the vendor of that product has a data breach and your records are part of that breach, then that vendor plus possibly the library could be liable for that breach. And when I say liable under the Library Privacy Act, that means that the person who is damaged by their records being, breached, can sue for no less than $250. So that's the lowest, but then they can also sue obviously for more than that. They can sue for their damages. If, let's say because of the breach, they, had, I don't know, someone took a credit card out in their name or, whatever it is, then they can sue for the actual damages that they suffered. They can also get court costs and attorney's fees, and that's really where a lot of money could end up being in the library's lap. The library could be charged for it, and it's also possible that the judge could request equitable relief, which could be anything from, could be money, but it could also be something like a formal public apology kind of thing. So that's the Library Privacy Act. And what's important there is that it's not just the library as an entity that can be sued. So the library as an entity can be sued if the breach is totally an accident. Like it's not anybody, nobody in the library did anything wrong. It just, something happened. Then you could be sued, for that. If it, let's say, for example, your vendor had a breach and the library could be sued as well as the vendor themselves being sued. Staff and boards and directors personally could be liable if they knowingly, so if they knew it was wrong, if they knew that they cannot disseminate patron data, but they go ahead anyway, whether it's malicious or not, then they can be personally liable. So you have to be really careful of giving out any kind of patron data to somebody who is not that patron. And those are things that, a lot of libraries already know and have procedures on. But in terms of a digital, in the context of a virtual or digital program, you want to be extra careful about that kind of thing. So you want to look at things like the program you're using, is it requiring patrons to enter personal information, particularly children? Then there's also at the state level, there's something called the Identity Theft Protection Act. And the Identity Theft Protection Act requires that an entity notify people if there's been a breach. So if your vendor has a breach, if the library has a breach of data, you're required to notify the patrons that are affected. And then it also has requirements pertaining to the destruction of data that is no longer needed. So if you're going through your ILS and you're removing patrons, then that is also something you're going to want to make sure you have a procedure on, is how are you deleting that data to ensure it's completely deleted. When you're done using that paper list of patrons who have overdues, you want to make sure that's shredded. And then you have the Federal Trade Commission, which has a lot of, that is kind of where the federal government has placed a lot of its digital oversight and digital protection. So that a lot has to do with consumer information, which would include your patron records. And so when they talk about unfair and deceptive practices as part of the Federal Trade Commission, they are also talking about the mishandling of personal information. So again, that could be something like, on top of the obvious things you think when you think about mishandling, like someone, just carelessly treating data, but it's also the idea of not being sure that your online or virtual platforms are secure and safe for your data. So that's another thing you have to be careful of. And that's everything from your internet provider to your ILS to any kind of product you use to do virtual presentations, if you anticipate that some kind of personal information is going to be involved in that. So those are things you're going to want to talk to your IT person about to make absolutely sure that the library is in compliance. Because as times move on and as more and more things become digital, and as there becomes this bigger emphasis in the law on cybersecurity, I think this is only going to get more important. So it's, and we will probably do a cybersecurity session, but that's just something, as far as your virtual presentations, it's something that should be up in your mind. Then you also want to make sure that you take a look at your online product when you're considering which product you're going to use, whether it's Zoom or whether it's some other product you're going to use for your virtual presentation, YouTube. You want to make sure that you understand what the license terms are of that product, whether it's Facebook, whether it's Zoom. You want to make sure you understand not only what the privacy policies of that product as a whole are, but you also want to understand what your ability is to set privacy limits, if you feel that you're going to need to. You want to understand what kind of user restrictions you have access to, so that if someone is causing a problem, can you boot them out? Can you mute them? Can you turn off their camera? Then you also want to understand how, things like license terms, like how many people can you have at one time? How much time do you have on the product? If you're using a free platform, it might not be as much time as you think. Can you use it for, if you're doing some kind of game and you're going to record it, is that going to be a problem? So it's all, all those kinds of things. You want to just really take a look at your user license, whether it's something you purchase like Zoom, or whether it's something like, Facebook that you can use for free. You're going to want to just really take a look at it and make sure, because sometimes there are differences between like what we would call personal use, which would be if you were sitting down with your children, or if you were a grandparent reading a book just so over Facebook to your grandchildren, as opposed to the world, or as opposed to the fact that you're a public library and a government entity that is reading that book and going to be posting it for the public. There are some differences there. So you want to make sure you understand, does your platform provide a, distinction in the license between personal, non-commercial use and, organizational use and commercial use, right? So you would be like an organizational nonprofit use or government use. Because you're not making money off it, but by the same token, this is not personal use. So those are the kinds of things you want to take a look at, because depending on those restrictions, you may have to, structure your program a little differently, or you may have to, that may make a decision for you on which platform you're going to use. So you want to, when you're planning a virtual program, on top of, those other things we just mentioned, you're going to figure out what kind of activity am I going to do? Who am I directing this towards? Is it kids versus adults? Am I going to do a game or just a straight presentation? Am I going to be distributing this event to individuals, say a group of patrons, maybe all children, the patrons, parents of young children? Am I going to be distributing it to teens, or am I going to be just saving the event on a platform where everybody can watch it? Or am I going to be putting it behind what we might call just went on my head, where like a passworded wall, right? Not a paywall, but like a password where people can only have access to it, say, if they have a library card with you. So it's not open to the general public. And then are you going to invite feedback or distribute a survey about the event? Now, if you're going to have, depending on the type of activity, right? So is your activity going to be a conversation, like a book chat or a book club? Is it going to be like a presentation or a lecture where the audience is largely passive? Or are you going to have a game, where it's interactive, or potentially things like a raffle, or something where prizes are going to be awarded? So each of these have some different legal considerations. So some of the things that you have to kind of consider with that are, first of all, would be copyright. Okay, so this is kind of a copyright can be very, very complicated. And one of the things that makes it complicated is for almost every use of copyright where you don't have get permission, you have to do that fair use, 4-step kind of walk. And the problem with fair use is that in the end, what determines whether or not something is fair use is a court and a judge. So all the rest of it is pretty much, our guesswork, right? It's an estimate based on walking through the fair use questions. So, sometimes it's very clear, but a lot of times it's not. And so we're just kind of taking, a leap. So your best defense here is to, when you walk through that, fair use analysis, is to make sure that you have all your ducks in a row as much as possible. And for those areas where you're not exactly sure, you want to make sure that you either note or that you have support for the reasons why you decided it was fair use, if you are going to consider it fair use, because these are a lot of gray areas. One of the things that you walk through when you think about fair use is, it asks if it is educational, right? That's one of the things you consider. And libraries, a lot of stuff, it is educational, but one of the things you have to be careful of is there is this concept known as educational fair use, right? And educational fair use is largely a myth, because it really is very narrow, right? So educational fair use really only applies to institutes of learning. It does not apply to public libraries. So when they talk about educational, they're talking about institution. They're not talking about the material, right? They're not talking about the libraries presenting material that is educational. They're talking about schools in the context of a classroom. So like virtual classrooms. So that's an important thing to consider, right? Libraries cannot take advantage of educational fair use. So you can't assume that's just because it's educational, you have that fair use capability, because that is not true. One of the things that has been most discussed when you consider copyright and virtual programming, like, for example, story time, is this idea of reading the books. So books are copyrighted, right? The illustrations are copyrighted, the text is copyrighted. If you're going to do a virtual story hour and you're going to take a very new kids book and you're going to read it out loud and present it to, you know, kids virtually, that's fine, but you want to be very careful about posting that. So it's not necessarily the presentation that is the problem there. So presenting it live is not necessarily the problem. The problem is posting it and saving it and recording it. So you want to be very careful about posting that without permission if it's a new book. Most of the time, authors and publishers will give you permission, but you have to go ahead and ask for it. During the pandemic, there were several publishers that gave a free pass to this, but those free passes in a lot of instances are no longer applicable. If you're using a book in the public domain, then you're fine. You know, an older storybook. So a lot of times things like, you know, fairy tales and stuff are most often, as long as they're in the public domain, not a problem. So you want to be very careful about that, right? Because again, just because you're doing it for good reasons and just because it's a educational thing does not mean that you get a free pass for posting it on YouTube for the whole world to see whenever they want. The one thing you might want to consider is that if you take your recording, so you walk through your analysis and you really believe that this particular presentation is covered under fair use, one of the good things you can do that, you know, to kind of really help your situation is to post that presentation in a passworded forum. So post it in a way that only, say, patrons of your library can access it. So only people who have a library card can access it. Maybe they have to put their library card number in to get it. Maybe they have to put in their library card number to get the password to get into it. You know, maybe the library has an easy proxy or something that allows them to get in by virtue of, again, a library card, or they log into the library site and they can access it that way. In other words, presenting it in such a way that just any old member of the public from anywhere cannot access it. That can help you in your fair use analysis. You want to also look at images. So you want to be careful about, you know, the images you use in your presentations. Again, this could also be things like illustrations from a storybook. If you show them briefly, you know, just like, you know, a second or two, then you're probably okay. But if you're going to keep them up for long periods of time, that's something that you might want to be careful of. If you're going to use images, commercial images in you know, any part of your event, you want to be very careful about that. Because if you post it online, even if you're just having a game or, you know, a discussion, then if you have images online, now I'm not talking about like the cover of the book, right? So that's largely very often considered like advertisement. So a lot of times that's not as much a problem. The cover of the book is not really going to be a problem. But if you're posting, like you're doing a Harry Potter trivia game and you have images, you know, commercial images from the movie or the books up on the website, or as part of your game board, then those are the things you're going to want to be careful of. So, you know, you might be better off using icons like wands and hats and things like that, rather than actual pictures from the movie, unless you have permission, unless you're using them from, you know, say a site, a stock site, or a you know, Getty or some kind of photograph system that you pay for. But unless you have the right to use them, you're probably going to want to stay away from that, because you could run into the same problem with these spiders that crawl the web from these rights companies looking for commercial images, and then they, before you know it, you get a bill saying you use this image. So again, that's another pitfall of posting it publicly. So you want to be careful about that. You can use, you know, public domain sites like Pixabay, which has photographs that are not licensed. And then you should also, when you're going to have a performance, so if you're going to have a storyteller come, or you're going to have a musician come, or you're going to have a, you know, magician or something like that, you're going to want to talk to, look at that contract or the MOU you have with that performer and make sure that they don't have a problem with being videotaped or recorded or photographed, and that all of the materials they use, they have the adequate permissions and copyright to use. And that includes music in a big way. If you have a performer who is either playing music or using music, you want to make sure that they have all the appropriate permissions if you're going to be recording and posting this. Same thing with video clips. You're allowed to use a certain amount for fair use. It's like a few seconds. If you're going to get into larger uses, you have to be careful with both books and images as well as video clips. There are some kind of exceptions that we'll get into in a minute. And then I have a link to a very good fair use analysis that kind of walks you through the process and can help you figure it out. If you are not sure, if you get through the First Amendment, if you get through the fair use analysis and you decide, oh gosh, I really am not sure, better safe than sorry, right? If you're not sure, don't use the material. It's better, to err on the side of no fair use if you're not sure. Gaming. So gaming is kind of interesting. Michigan's gaming law is actually pretty restrictive. If you are going to be playing, say, a trivia game for prizes or a bingo or a raffle or something like that, you have to be very, very careful. I can tell you that something like a raffle, there is almost no situation where if you have a raffle, you do not have to get a license from the Michigan Gaming Control Board. So that's very sticky. So you always want to double check, go on their website and double check the circumstances under which you need to, contact them and get a license and sign up. If you really are looking to have something completely informal, one way you can get around the gaming requirements is do not have participants have to give you anything in return for participating in the game. So if you want to have a raffle, then, and it's just for fun for the game, then just make it so that, the participants don't have to pay for it, don't have to provide anything of value in order to be part of the raffle. And if you do that, then you don't have to worry about the gaming laws. You want to make sure that you have clear rules for any kind of game so that, you don't have someone later telling you that, it was unfair or it was discriminatory, or, you want to be very careful about how the game is conducted, especially if you're going to be posting it, right? You should be careful of that anyway, whether you're posting it or not. But if you're going to be posting it, it's particularly important, because if someone complains, then the video obviously is going to reflect what occurred and could be looked at in, several different ways. So you want to make sure that, you have a list. Probably a good idea to write the rules down and post them as part of your presentation so that all of the participants are very, very clear on the rules. You want to make sure the rules are enforced neutrally, just like you would enforce library policy. So the kind of rules, things like, make sure if players can, if one player can win multiple times, right? You want to be careful about things like if the staff running the game have a child in the program who is playing the game, right? So you want to consider the optics of, it could be the most innocent thing that you could think of, but if the staff member's kid keeps winning, then people are going to get upset, right? So you want to be very careful about, this kind of conflict of interest idea. Again, specifically, if it's been posted. And the reason why I say that is posting stays there forever, right? So if you have a game or a presentation live in the library, yeah, mistakes might be made, or something might happen, which we hope it doesn't, and we expect that everybody will act appropriately and fairly, and but sometimes things happen. And if it happens in real time, and then it's done with it. and people may complain, and sometimes there's the he said she said thing, but in a video environment it's there, right? So it's recorded, and there's no doubt a lot of times about what happened, or it could sometimes give the wrong impression about what happened depending on how the video was filmed and how everybody is perceived on video. So you want to make extra sure that everything is kind of copacetic and you're doing exactly what you're supposed to be doing, and you're being very careful to avoid things like conflict of interests and unfairness and all that kind of stuff. Not that you wouldn't be anyway, but it's just kind of an extra reminder. If you're doing a performance, so if you're hiring someone to come in, as I said before, you want to make sure you read the contract carefully, make sure you understand what is included for the price. Now, these are things that you may think, oh, I've been doing this for years, I know this. But in the context of a virtual presentation, what I'm talking about are things like, do they mind being photographed? Do they mind if you post this in a public space? Because if you are a certain kind of performer, maybe you're a storyteller. If a public library posts publicly your performance, then that could affect your ability to get hired somewhere else if it's all over the web and people have seen it already a million times, right? So some performers may say, no, I don't want my recording to be posted. You can record it and you can give it to members, of your library community, so it can be accessible to, library card holders. Or people who attended, but it cannot be posted publicly on the web. So you want to verify whether or not they have a problem with posting it publicly, or whether there might be an extra charge for that. You want to make sure that if what their materials are, and are their materials copyright, do they have their materials permission to use whatever copyright materials they may use, like I said, especially music, because music can get extremely expensive if it's not if it's being used improperly or illegally. Music gets astronomically expensive. Again, if you're going to be doing like a lecture, make sure that, again, same thing, make sure you're reviewing the contract for restrictions. Is there a participant limit? And this could also be the same thing with the programming if someone's doing a performance. Does the person, is there a difference between having 10 people attend or having 100 or 200 people attend virtually? So for some lectures that is a problem, for some it isn't. So it's just something good to make sure that there's no, you're not going to have any conflicts like right before it starts or when it starts or after it starts. In many of these instances, you can just ask the person you're hiring, say, hey, we want to do this virtually. Do you have any, particular requirements or charges or, requirements regarding virtual presentations? And then let the performer tell you. Chances are they've done this before. You always want to make sure that you have in writing, so you have an MOU or a contract with your performer or your lecturer. Again, the same thing, requesting if you can record it. And we already talked about the copyright. And now let's say you're having a book club. Well, again, anytime you have participants, you want to make sure you have clear and appropriate rules for conduct. You want to make sure that, the participants understand what is going to happen, what the expectation is of the, for the audience, what the expectation is for behavior. Now, you cannot restrict speech. Right? You're a public library, you're a government entity. You can't tell people what they can and cannot say. So that means you can't say, you can't curse, or you can't, use inappropriate language. You can't tell people that. What you can do is police behavior, right? So you can say that the expectation is that participants will act, will be respectful to the speaker, will be civil and respectful to each other. You can restrict behavior, but you cannot restrict speech. Make sure that you have what the consequences are for the rules of conduct. If you violating these rules will result in removal from the event. So that gives you the ability to just boink, hit the button and boot the person out. And you know, that's one of the things you look at on the platform is if you boot the person out, can you prevent them from coming back in? Or how do you prevent them from coming back in? So you want to make sure that people know what the rules are, right? You can have rules, but you also have to make sure they know what the rules are. That's part of kind of due process. And then again, you want to make sure, I cannot emphasize copyright stuff enough. And that includes, so since this is like a book club, there's different rules for critique in copyright. So they're a little bit looser. So if you're having like a book club where you're discussing a book, you can post passages from the book up. You can have illustrations from the book up. Things are a lot more open when you're having like a discussion or critique on a piece of literature or material or movie even, than if you are just doing like a storytelling. Or a game. So that's also important and helpful to know. But you know, it's okay in the process of the discussion to post like PDFs of pages and stuff, but in context of, you know, afterwards, you can't provide the viewer with the full text of the PDF of the book. Okay, so that would not be good. So that's something you have to really consider is what is put on the screen in the context of the discussion is okay, but what you're going to give to the viewers to take away is something else. So you have to be careful of that. Okay, let's talk about privacy issues. So what is personal information? Well, in the state of Michigan, personal information is your name, including if you use initials, your address, your phone number, your social security number, your driver's license, any kind of financial information like your credit card number or your financial account number. So if you're a library that has a virtual window for, you know, taking overdues maybe, or as part of the registration process for a card, you have the ability to pay for fines or, you know, pay or donate. You want to be careful again about the data breach and where that personal information is stored, who has access to it. There should be rules with staff who have access to that information on how they can treat that information. So that's, you know, kind of confidentiality rules. So that's very important. And then on top of that, you also have the Library Privacy Act, right? Which, you know, everyone should probably be very familiar with, as well as the FTC Act we mentioned earlier about, you know, having good measures in place for patron information and other kinds of personal information. And that would be staff personal information too. This applies if you're working at home. So if you're doing a virtual meeting from home and you're doing it over your own personal Wi-Fi, be very careful about access to patron information. If you are working from home and you're getting into your remote, like EasyProxy or your remote accessing the patron database, again, be very careful and understand what the protocols are for your home Wi-Fi in terms of data security. So again, that's a conversation with your IT person. And all of those protocols for if you're at home and you're looking at your registration list for your virtual program, that has to be secure. If you print out your list of registrants, that has to be secure, because those are all, depending on the information on there, that's personal information, and that is also covered under the Library Privacy Act. So, you know, that's all kind of things that you have to think about. It seems like, oh, I'm just going to see who's there. Let me just print out a list. so that, I know who's coming and I can call them by name, or, I can make sure I have a prize for each one. That's great, but make sure that you keep an eye on that documentation and what happens to it and who has eyes on it. You might want to consider in your platform that you're doing your virtual presentation on, if you have the ability to offer the option for people to use pseudonyms. For those of you that have been in the directors meetings on Fridays, you may notice on the document you see pseudonyms like lazy otter, or something like that. Double check to see if the platform you're using has an opportunity or gives users the opportunity to input an avatar name or a pseudonym in lieu of putting in their real name. So if like Zoom or the virtual platform you're using requires a participant or has an option that the participant put in a name or an email, I would probably not do the email unless you have you're going to follow up with, giving them the copies of the slides or something. What I would do is say, go ahead and put in a pseudonym so that you have a way to address people. And then that lets them make the choice. Then your participants are making the choice as to whether to use their name or to use a synonym. And this is particularly useful with children because best case scenario, you don't want children to put their names in. A lot of them would tend to put their full name in. You want to do whatever you can to restrict that. Don't have them put their names in. That's not a good idea. But you can have them put in a pseudonym. You can ask them, offer participants, particularly children, the option to be off camera. So make sure as part of the protocols, or the rules or the information that you provide to participants when they arrive into the program, give them the option to put their camera on or off if they want. Again, if you're with children, you may want to suggest that their parent join them in the activity. You may want to make it a welcoming thing so that parents are interested in attending, because that provides more security for the library and reduces the liability for the library if the parent is present. If the parent isn't present, again, I would do everything you can to give the kids options to protect their privacy, and make sure they understand that they have the option and how to use it. So how to turn off their camera, how to turn on, and I would probably mute them all. If you have that ability from the get-go to shut cameras off, I would probably do that if you're going to be posting it publicly. You may want to consider blocking chat, blocking the ability to chat between patrons or between participants, or if having the chat is integral to the participation in the program, that's fine. But then when you post the presentation, do not post the chat. Make sure that the chat is out. I can't emphasize that enough for so many reasons that I'm sure most of you can vision. You want, again, Library Privacy Act, children's personal information. You want to be very careful about that. A saved program with, if you have children's name and stuff in it, would be a library record. So that is, could be a problem. There's also the Federal Child Online Privacy Protection requirements, and actually it's a reg, which, if you're gonna be having minors give you their personal information, including like their email as part of a presentation, you have to get permission from their parents. So you may want to get in the habit, if you're having presentations for minors that will not include parents, you may want to include as part of that a permission slip, or a virtual, you could do a virtual permission option as part of the registration process. So that way the library is covered if you are, capturing anything. Same thing with gaming. You want to make sure that you don't hold the information for any longer than is absolutely necessary. So, again, that's another really good reason to get rid of the chat, or reduced by any material that you're using. I would not post any kind of thing, presentation on the web that has kids' names attached to it if you can avoid it. And that includes, like, if you're doing a Zoom presentation and you take a recording of that and post it, you might want to double check and make sure kids' names aren't like on their box like mine is right now. It says Claire Mambiella. That's another really good reason to use pseudonyms. So you could require pseudonyms. A lot of this is just making sure that you really understand the product you're using and you really have a very good handle on all of the options that product permits you with regards to participant privacy and participant information. So that's a really huge thing in all of this. Again, if you're going to be recording kids and you're going to be posting that, it's always a good idea to get permission from parents. And again, that could be part of the registration process. Again, I highly recommend posting to sites that require some kind of the word again just left me, require a password or some other kind of formal registration in order to get into it. So that, and perfect example would be the only people who can get into it is people who have library cards from your library. So they have to input information like their library card number in order to get access, or they can get access through a gateway on the library site that enables them to view it. So that, again, that can help you a lot in terms of a lot of this privacy and copyright stuff. So the other thing we have issues with here are participant issues. So aside from all of the privacy and the copyright and all of those issues, you have just the interaction issues with people, right? So you always want to make sure that you work with another staffer, right? So that you can team on this. You're not just by yourself, because it can be a lot. As any of you who've done a webinar or anything know, it can be a lot for just one person to handle a presentation. This presentation, like that I do, is pretty, not difficult in terms of managing participants. Y'all are a really good group. Y'all tend to be very civil. You tend to not be rowdy and, problematic. And I have Becky here to help me. So I partner with Becky, because even just, keeping a handle on chat and trying to, if there's technical issues, even under the best of circumstances, it can be a lot to handle a virtual presentation or a virtual meeting. So it's really helpful and sometimes very necessary to have a partner, right? Especially if you're going to be having kids involved. You want to have a partner that can help you monitor things, but they can also back you up and be another set of eyes or a witness if someone alleges a problem, right? So that it's not just, your word against their word, or it's not just you as one person saying, oh yeah, I completely saw everything that was going on in this virtual program of 30 children, because that's almost impossible, right? But if you have another set of eyes and there's 2 or more of you saying, no, we saw this, then that becomes a little bit more reliable, a little bit more valuable evidence, if you say. Always have rules of conduct for any kind of presentation program that you're going to have. What behavior is expected, what will happen if the rules are not followed, what are the rules with regards to asking questions or talking during the presentation, what are the rules regarding do you have any rules with respect to interaction with a performer? And that may be partly what the performer, wants. Can you do Q&A? Does the performer permit that or no? So that's something else you would ask with a performer. You would, someone you're bringing in from the outside, you would never just assume that it's okay to have a Q&A in addition to their presentation. You'll always want to make sure that you double check on that. And you want to make sure, again, that your participants know what's going to happen and are understand the rules under which this program is going to function. Make sure that it's enforced, that it's neutrally and fairly enforced. You may want to, as much as possible, with an eye on also making your presentation enjoyable and functional, limit participant actions. You know, in terms of, you know, muting or camera, or it's always a good idea, again, depending on what your program is, right? So for a performer, it can be very difficult to perform when you can't see who you're performing in front of. So there may be some different choices to make there, whether or not you can keep everybody's camera on, or whether you can turn everybody's camera off, or whether you're going to allow them the ability to do that themselves, can really depend on the individual program, right? So, and the ages of the participants. So that's something also to consider. You want to make sure that chat, right? Can they use chat? If they do use chat, make sure you have rules about chat in there, in terms of, you know, keep the discussions pertinent to the program. So you don't have, you know, teenagers talking about whatever on the chat, or better yet, teenagers putting stuff in just to make it kind of funny. So, or what they think is funny. So, you know, those are the kinds of things you might want to, you know, address and anticipate. If you have people zooming in from all different places, ask them to blur their backgrounds. Because you don't want copyrighted images in their background in your recording if you can avoid it. Cyberbullying. So Michigan has a cyberbullying statute, and I have the statute number there. So the law does not, it's mostly schools, and so the law does not specifically mention libraries. There could be some liability there if there is noticeable bullying going on, like in the chat, against one particular child or against one particular person, or if there is, you know, hate speech. Now, again, I talked about you know, you can't restrict speech, but even the First Amendment has some limits, right? So if it's inciting speech, or if it's what they call fighting words, you know, that's the kind of speech that can be restricted. And it's also, you know, if you have your rules and you say, you know, only the chat should only contain discussion pertinent to the program, then if you have somebody who is just going off and insulting or bullying another person, you have that option now to say you are not sticking within the rules, and we are going to now remove you because you are violating the rules. You can say, you know, first you have to stop, warn them, you need to stop this. If they don't stop it, remove them. So that's another reason that's important to have clear rules as part of your presentation. Because even though librarians are not mentioned in that law, doesn't mean you couldn't be up for liability if there's something, you know, noticeable that occurs and the library, you know, the program runners don't do anything about it. And then, of course, there's this bombing kind of phenomena that was happening, or, you know, once in a while still happens, that has to deal with, you know, someone, you know, logging in inappropriately and, you know, putting sexual content up. That can largely be handled by dealing with the settings in the product that you're using, in terms of making sure, you know, limiting what the participants are able to do, and considering your audience, you know. So, you know, that's probably less likely with kids, although it can happen from outsiders. So again, one of the best protections against this is to really understand the security and privacy options on the platform you're using, and using those to minimize that possibility. ADA accessibility is another big concern when you're talking about virtual programming. You have to make sure that when you publicize the program or the event, you indicate that people who require accommodations, you know, contact you. You can say, you know, we are happy to provide or people needing accommodations, please contact and give an email or a phone number. So the kinds of accommodations most likely you would be asked to provide would be things, accommodations for hearing impaired, accommodations for sight impaired. So this would mean things like, or, some other, could be, some other possibilities, but, kind of, I think a lot of them would be related within this idea of hearing and seeing. So that would be things like making sure that the product conforms to web accessibility guidelines, the Internet Web Accessibility guidelines, so that the website can be read by screen readers and other kinds of tools used by people with hearing and sight disabilities on their computers. You may want to prepare to be asked to provide either an interpreter for sign language and or a transcript or captions for the event. So depending on the platform you use, different platforms can provide a transcript of events or captioning of the individual screens. For the sign language interpretation, there are different options available. There are sign language interpreters through different nonprofits that you can request. And also through the state that you can request. But again, a lot of times you need a little time ahead. So that's why you ask people who need these accommodations to please request them ahead of time so that you can properly put them in place. You do have to accommodate. So you can't say, you can't tell someone you won't accommodate. You don't always necessarily have to do exactly what they ask. If doing so would either put the library in a dangerous financial position, or put an undue financial burden on them, or if it would impede the operations of a library. There are very specific exceptions. So it's important that you consult your attorney if you have a reason why you think it's going to be difficult to accommodate. Before you tell the person no, make sure you check with your attorney. Because the law says that when it comes to like a lawsuit or something, the law should be interpreted to err on the side of accommodating, right? So you could be putting yourself in a bad position if you were to be sued if you just outright say no without really investigating it first. I have a link here for you to look into things like screen readings, whether or not the platform is optimized for a screen reader. And I think that's most of the ADA stuff. And this is choosing a platform. We talked about some of this stuff. Participant joining options. Make sure, I can't emphasize enough, understanding the tools that the product gives you. Do you have, again, we just talked about accessibility. Realize that if you're using a free version, like a free Zoom, be aware that sometimes there are time limits of those products. So you may only have 30 or 40 minutes as a free product. Double check if you're using like Facebook or Google, if they have any time limitations, so that you understand and you're not stuck, and your program doesn't just end without you being finished. You also lastly want to make sure, at the bottom here, I have the social media bit put in. So if you post your program, like let's say you're done and you record it, you have everything, all your copyright, all your permissions, everything done, and you post it on social media, like your Facebook or Twitter. One of the things you have to be very careful about is consider disabling the comments from viewers after you post it. And the reason for that is, if you open your comments for just any member of the public to put stuff in, that changes, how we talk about limited public forums and designated public forums and open public forums, that can skew now your public forum status, because the internet is a public space, And once you open up your comments for anybody to put anything, there are courts that have determined you have now turned that into a public space, a public forum, not a limited public forum or a designated public forum, but a full public forum, which means that is the widest right of speech. And that means that anybody can say anything they want and you can't delete it, right? It would be a problem to just delete it unless, it's going under those, fighting words or inciting, which again have some very specific legal definitions and may not always be what you think they are. Okay, so just because someone calls someone a nasty word does not automatically bring it into inciting words. So it's important to, again, discuss this with your attorney because there's lots of pitfalls. But what you don't want is to be in a position where you have negative comments and now you want to just remove them. That could be a big problem because of this issue of public forum. One of the best ways to deal with that is just disable the ability to make comments for this kind of thing. And that way you don't have to worry about it. And we are going to get into that more when we do the social media presentation. Okay, I have some resources here, more information on data security, more information on accessibility, and that's it. So I hope this was helpful. I see that we have a few questions. We do have some time. So let's go ahead and take a look at some of the questions. Add-on product options in Google Forms. Are they third-party vendors? It's hard to know what they do with that info. The important thing to look at in this in this situation is there should be, and I have to admit, I don't have a huge amount of experience with Google Forms. I have some, but I don't have a huge amount. They could be third-party vendors. It could also just be part of Google, but there should be something within Google, either their terms of use or within some of their documentation that says whether or not what these add-ons are. A lot of these bigger companies will also have documentation. Look at their privacy statement. A lot of times when you go to Google, you'll see there'll be a little privacy. When you're in Google Forms, click the privacy information link, and it may address the third party or the add-ons. Because, one of the things they would want to do right away is disavow themselves. Oh, we're not responsible for this. So that would be the first place that I would double check. After that, I would check with your IT person who probably is more familiar with the technical aspects of it, as opposed to what I know is mostly just, a legal question. But since this is about a specific product, I would do that. I would look at the site and look at their privacy and their licensing and see if either one of those mentions it, because it's probably bundled in. There may also be something that when you choose one of those third parties in the process of going through and adding it, you may see a little link that mentions either privacy or further information or something like that. Let's see what else we have. Is there a responsibility on the part of a participant to anonymize themselves for privacy? Unfortunately, this is kind of a more difficult question. When we're talking about data, if we're talking about like two different things, if we're talking about data security, in terms of privacy and data security, the onus is completely on the library to understand the product they use and to minimize it, because you're the one that's going to get in trouble. If it's the question is something like, having their picture, right? You can easily, cover that by having a notice that says you are being photographed. and then, you know, they can opt out, right? So they could say, I don't want to be photographed, so I'm going to close my camera. So that gives them the option, but you have to let them know that it's being filmed. If you don't let them know it's being filmed, then again, the problem is yours and not theirs. Because now if they were walking into the library physically, then you could say, well, there's no expectation of privacy in a public space, but there is the Library Privacy Act, which covers their, you know, parts of their privacy, and that Library Privacy Act also applies online. So even though largely what you say would apply in a lot of situations, it would not always apply in this situation because of the restrictions and the responsibilities placed on the library by the Library Privacy Act and by these other laws that require, you know, data privacy and privacy for children and that kind of thing. There should be a way that people can change their avatar or their name on the screen. And so that's something that you would want to investigate, to give them the option in a public program to either put their name on or not. You know, when you're dealing in a work environment, it's kind of different, but when you're dealing in a big public space, you should have the ability to either have your name up there or not. And your platform should give you the ability to do that. Attending a Zoom program contains their name, but it contains their name because they have to put it in, right? So either they have a Zoom account that puts their name in, or they, you know, it could be a part of the registration process. But I believe, hey Becky, there should be a way that they can change what their name is. Is that correct on Zoom?
There is, yes. If they on the participant screen, if they right click on the more button, they can rename themselves right there.
Okay. So that maybe is probably something that you'll want to put in information for the program, is to let them know that they can change their name. You know, you can put that as part of the rules, or so that they have that option. I would certainly recommend that. Okay. Oh, does social media become a public forum in the sense that we can't delete comments from our regular postings? If you're talking about a personal social media, mostly what I have looked at is in the context of like public libraries or businesses. And the consensus seems to be that if the business or the government entity has a social media presence and they open up public comment, then yes, it makes it very difficult and sticky to remove those comments. So one of the options is to just limit the comments. Now, there are some nuances that you may want to talk to your attorney about. It is possible that you could have some rules for how people can, you know, what that form is meant for. But again, because of the First Amendment issues, I would talk to your attorney before you mess with any of that. I would say that unless you have a compelling reason why you want comments, to disable them. If you want them, that's fine, but you have to be prepared that you have to just take the bad ones with the good ones. And you know, that's kind of just the way it is. But like I said, we are going to have a session on this, and we'll go into more detail on it. Should we have a standard library contract for all performers? Here, I'm going to stop my share. Some performers have their own, but they do not, but many do not. Yes, I would definitely have your own contract for performers. I think that's a very good idea, because it not only will you be able to make sure that it has everything in it that you need, but remember, if it's your contract, it's going to be, you know, drafted to protect you and to address your needs. If it's the performer's contract, then it's addressing their needs. So what I would do is have something in the middle and have the library draft a contract that they use for performers. And if the performer needs something extra, then it could always, and the library agrees, it can always be added to the library contract. But that way, that these important issues, like the issues of privacy and copyright, are addressed. So I would certainly have either a memorandum of understanding or a standard contract that you use with performers. You could use DocuSign if you want. DocuSign, there's always going to be the data breach anytime there's information on a platform. But in this instance, because you're not having patron information as part of that contract, it's just the performer and it's the library signing. The contract would be public record, so that if there was a data breach and it came out, that wouldn't really be a big deal. The problem with data breaches is that personal information of the public. So the performer signing this, that's not really a private information thing, because this would be a publicly available contract. The problem is the list of patrons attending your Zoom with their email addresses. That's the kind of public information that you don't want to get out. And I think that I've gotten through all the questions. And oh my gosh, we're actually done a little early today. So that's kind of a good omen for Friday, right? I'm not keeping you past, my son's in my face, I'm not keeping you past the time that we normally meet. So I guess, does anybody have any other questions that they would like to, oh, that made it worse, that they would like to talk about? Now I cannot deal with this son. That's great. Okay, I'm going to be like a YouTube myself here. Okay, I do not see any more chats. And so I guess we can go. I want to thank everybody for being here. I do have a little bit of exciting news that you guys are going to hear about next month's webinar. So next month, we're going to talk about First Amendment issues and challenges, materials challenges that for books and all of this kind of censorship stuff we've been dealing with. And I've in discussions with the people at the Office of Intellectual Freedom from ALA, and they have agreed to come talk to us in December to do my monthly spotlight and to talk to us about how to deal with a materials challenge and policies on materials reconsideration and intellectual freedom. So we're waiting for confirmation of a date, but I'm very excited about this. So you will hear more about it. So I'm going to leave you with that. We're very excited about that. And I hope to talk to y'all soon. I hope y'all have a great Thanksgiving and have a really good weekend. And I'll talk to you soon. Thanks a lot.